No, he just punched me. Everything for no reason. Right, go. Let him fucking go. Let him fucking go. Let him fucking go. Let him fucking go.
That's a cop.
And that's on me. Shit. No, I didn't. I don't punch niggas. Don't punch me. No.
Ma'am.
Take me where you want to take me.
I can't take
no,
you. I don't
take
have any
me.
identification on
And
you.
I don't care. You don't need the identification. You have locked people up and you have picked up dead bodies when you don't know who bodies it was, but you picked them up. Take me where you need to take me.
I'm trying to.
No, take me where you need to take me immediately, expeditiously.
You have prevented
Take me. I could give a damn. Take me where you want to take me.
So how do you want me to take you somewhere expeditiously?
Now. Take me where you want to take me.
There's nothing more powerful than the odor of mendacity.
And good evening. Welcome back Inside the Law. I'm your host, Philip Holloway. We have a now former judge in the Atlanta area. You just saw former Judge Christina Peterson, who was the probate judge in Douglas County, Georgia, until about 2 weeks ago when the Georgia Supreme Court removed her from office. Now, you might think, well, okay, if you're a sitting judge and you get arrested for, assaulting a police officer, obstruction of an officer, attempting to maybe strike a police officer, that, yep, you're going to get yanked off the bench right away. And sometimes that might be the case, but in this particular situation, the timing of all this is sort of coincidental because it is not her arrest for what you just saw that got her removed from office. But so let's take a look first, before we get into the legal case against ex-Judge Peterson. Let's look at sort of what the new allegations are that landed this judge, former judge, behind bars in the Fulton County Jail. All right, so we're looking at this is from Atlanta's First News, and this is dated June 25th. Douglas County Probate Judge Christina Peterson has been charged with a number of violations of the Code of Judicial Conduct, including a number of violations that the JQC, Judicial Qualifications Commission, says exhibited a pattern of judicial misconduct while in office. The court said in a ruling issued Tuesday morning, the JQC hearing panel found that Judge Peterson violated multiple rules in the canons of judicial conduct, and that two of those violations warrant her removal from the bench. Okay, and then they give you the entirety of the it's like an 80-something page ruling, so we're not going to go over all of that, but suffice it to say, we're going to certainly talk about it. From that arrest, she's facing two charges: simple battery against a police officer and felony willful obstruction of a police officer. And in Georgia, the felony version of obstruction of an officer is when you offer or actually do violence to a police officer. So the allegations is that she was arrested at the Red Martini Restaurant and Lounge off Peachtree Road. There was a 911 call. After her arrest, her attorney, Marvin Arrington Jr., who, by the way, we have talked about before here Inside the Law. And in case you don't remember who Marvin Arrington is, let's just take a trip down memory lane.
We got a signed letter of intent. Shut up.
Just come on. Just a minute.
Shut up. I'm talking.
Just a minute.
You're not talking to me.
Shut
You're
up.
not talking to me.
Shut up. I'm talking.
Make me.
I'm talking.
Make me.
I'm talking.
Make me.
It's my time. It's my time.
Make me shut up.
It's my time.
I didn't think so.
Yeah.
Is that off?
No,
Yeah.
Yeah, so Marvin Arrington Jr. is a member of the Fulton County Board of Commissioners. We've looked at Marvin Arrington before in a number of contexts here inside the law as it pertains to Fulton County. We've discussed that he's the one who has, sort of as part of his position on the Board of Commissioners, they set the budget for Fulton County, including the DA's office. But in any event, you see how we're getting a lot of overlap here of some of these recurring characters. But in any event, Arrington says Peterson stepped in to help a woman who was being viciously attacked by a man while at a restaurant. She was the only one that helped me. Alexandria Love, the woman at the center of the incident, said. Love said she was attacked by a man she didn't know. She said Peterson, who was standing beside her holding back tears during the conference, didn't mean to hit an officer during her attempt to break up the alleged attack. And of course, everybody's presumed innocent, and these are only charges. She's not been found guilty of anything at this point, but it is what it is, and we can see the video. And this is not about whether she's guilty of a crime. This is about her fitness or perhaps lack thereof to hold judicial office in Georgia. It says that Arrington confirmed Peterson learned of the Supreme Court's ruling Tuesday morning. See, all this happened right around the same time. The ruling from the Supreme Court and this arrest all was right there together. It says they're calling for the charges to be dismissed. Peterson, 38, was sworn in as a probate judge in December 2020 after winning a contested Democrat primary that year, and then she ran unopposed in the general election, there being no Republican challenger. In any event, there's more video that I'll share with you real quick. Just a moment. Here we go. Let's see what we can see here. This is more video from the back of the police car. Well, having a technical difficulty with that. So here we go.
I want everybody to know I'm not suicidal. If anything happens to me, I did not kill myself. It was this officer who has me in the back seat of his car. False arrest, false imprisonment, malicious prosecution. This man has beat a woman outside of Red Martini, and then he beat me to the ground and put me in handcuffs. My people told him, and they pled with him not to take me. They told him who I was, to no avail. Please understand, good people. If anything happens to me, it was not me. Please look for me. Please try to find me. And please understand that I was never, ever, I was never suicidal. I would never kill myself and never do any harm to myself. It would have to be somebody that did it. And it's this man, Wadsworth, whatever his name is, City of Atlanta Police Department. I'm sitting outside the police department. I've probably been sitting out here for an hour, almost 2 hours, and I have not been booked in on no crime. I'm about to own the police department once I get out of these handcuffs. I'm about to own the police department.
All right, so we won't go into the entire 10 minutes of that, but look, if it takes a couple or 3 hours to get into the Fulton County Jail, wait until you figure out how long it takes to get out of the Fulton County Jail once you post bond. But that's a subject for another story. All right, so what does this all pertain to? This whole business with the Judicial Qualifications Commission and the activity pending at the Georgia Supreme Court. I want to share with you here we go. I want to share with you, this is from the Supreme Court of Georgia's website. You can see this is the case involving Judge Christina Peterson. There's formal charges, there's various motions. When we talk about, like we did yesterday, the Supreme Court having original jurisdiction, this is an example of original jurisdiction. This entire legal proceeding takes place in the Supreme Court. There is no other trial court. So there's a formal charges, which is analogous to an indictment in maybe a criminal case. There's motion practice because there's rules for all this. There's rules and there's laws and there's all sorts of things. And so there's a formality. Even judges who engage in misconduct are entitled to due process. And we've talked about due process here before. That's what all this is. You got a motion to disqualify. My guest tonight, Charles T. Boring and Courtney Veal. Chuck is the former director, and Courtney is the current director of the JQC. There's orders that the court enters. There's answers. There's amended charges. There's scheduling orders, all sorts of things. And you can see this has gone on for a long time. Finally, we get to the Supreme Court opinion dated June 25th, 2024, and they begin their order here. It says, we have explained before that the judiciary's judgment will be obeyed only so long as the public respects it, and that respect will not long survive judges who act in a manner that undermines public confidence in their judgment and integrity. In this case, Douglas County Probate Judge Christina Peterson has been charged with a number of violations of the Code of Judicial Conduct, including a number of violations that the JQC says exhibited a pattern of judicial misconduct while in office. The hearing panel found that Peterson violated multiple rules and that those violations warrant her removal from the bench. So this is not about the arrest. This is about things going back a few years here. And then they say, we agree that removal is warranted here. And they explain, and this is an 82-page opinion. So you'll either be happy or not happy, but we're not going to be able to go through 82 pages, not here tonight. But what we can do is we can talk about the charges that the JQC brought against her. And there's no better person to join me than the former director of the Georgia Judicial Qualifications Commission, my friend and colleague, Chuck Boring. Chuck and I have known each other for at least 25-ish years. I would have to say, I mean, don't test my memory on that, but I think that's probably about right. Chuck is no longer the director of the JQC. He's an attorney in private practice, former prosecutor in Cobb County, and if I'm not mistaken, also Fulton County many, many years ago. So a big round of applause. Let's welcome inside the law my friend Chuck Boring. Chuck, good evening. How are you, buddy?
Good evening, Phil. Thanks for having me.
Oh, man, glad you could do it on relatively short notice. I've been traveling some for the last couple of weeks, and so I've not been able to do as many of these live streams. And this news, Chuck, broke when I was in Alaska, and in a different time zone with very limited access to internet. So it was something that I really, really wanted to talk about. And I know that people who watch this channel have been very interested in it as well. Look, so I started looking at this and I'm thinking, I'd like to just explain what's going on to these folks. But after looking at it, Chuck, it goes back years and years and years, and your name is mentioned in it. And so I figured if you're willing to help us understand, what happened, what this is all about, I would just let you do it because I can't think of anybody more qualified.
Okay. Thanks, Phil. Yeah. I took over as the director of the JQC back in December of 19. Christina Peterson ran for probate judge in the spring of 2020. And that's the year she won office. And so, before my first year was up, we started getting complaints about her filed with us regarding her conduct after being elected, but before even taking office, regarding her actions on social media. And so, our dealings with Judge Peterson went on for several years until I left in January of 2023. By that time, we had filed formal charges against her, former ethics charges. And so my predecessor, Courtney Veal, who took over for me as the director, ended up trying Judge Peterson on these charges this past fall. And the hearing panel recommended she be removed, and the Supreme Court agreed.
Okay.
Um,
So I was able to download the charges, and that document itself is very, very large. So I've sort of cut to the meat of them where I don't know if it was you or somebody else that drafted this, but in any event, there's a lot of background information, some of which you just alluded to, which is like the social media stuff. And so I think it might make sense if you're willing to do it. We don't have to go through them verbatim, but we can look at what some of the more significant charges are. And maybe you could explain to me and everybody else sort of, why a judge shouldn't do that. So right out the gate, we've got here in count one, we can see that, there's allegations that she posted the Rose Bar post on Instagram account where she was advertising for an event at the Rose Bar using her judicial status as part of the advertisement. What was that all about?
Yeah, and this was kind of part and parcel of several things she was doing post-election. And one interesting thing, just as an aside, when the Supreme Court issued their opinion removing her from the bench, they did not even get to the merits of a number of the charges in the charging document, because they said not that they hadn't been proven, but because they were just unnecessary, because some of the other things were just so bad. This kind of started it all, though, this type of behavior. What was improper about it was, judges can always, they have private lives. No judge wants to have to live on an island, secluded away from everyone. However, there are certain things when they take the bench, they have to agree to do. One thing they can't do is use their judicial status for personal benefit or the personal benefit of somebody else. On her different Instagram accounts where she had listed herself as a judge, those types of things, she was asking for money on her birthday for people to send her cash. She told us people actually did. She advertised a specials wine bottle night one night, using it as basically her judicial status to advertise that. She also still had up on her Twitter account a video that was pretty offensive to many different communities and demographics as well. I won't even go into the details. I think the charges speak for themselves.
Well, I mean, I don't know if you hope you can you see what I've got put on the screen?
Yes, I can see it.
So the charges, and look, and we don't have to get into all the details either, but suffice it to say, the charges says having available for viewing on her Twitter account a video where she discusses homeless sexuals and makes inappropriate sexual commentary. And we can leave it at that. We don't obviously have to go too much deeper, but is she a judge, a sitting judge when she's doing this?
She's actually elected and hasn't even been sworn in. And she had violated, in our opinion, the Code of Judicial Conduct several different ways in this manner. And, we tried to talk to her about it and hope to reach a resolution, because something like that in and of itself would not warrant removal or maybe even public discipline of a judge if there was an opportunity to rehabilitate and, make things right. The problem with Judge Peterson throughout this was every time we got a new complaint and investigated it and were ready to go forward, we got new complaints, and it was basically on a rotating basis that all this happened.
Got you. Well, and by the way, in case anybody's curious, there is in this charging document, I will say there is more detail in the initial portion of it that you can find on the Georgia Supreme Court's website. That's where I got it. It's public. It's out there for the public to see. We don't need to get into all the details here, but if you're interested, you feel free to find it just the way I did. And by the way, I want to say welcome again. There's now 1,100 people in here. At the very beginning, I mentioned this is Inside the Law, where we take you inside the real legal system, not the one that you may think we have from watching TV or the movies. But look, we get into the good, the bad, and the ugly. And yes, sometimes there's very ugly that pertains to those of us who work in the system. And this is a very, in my opinion, ugly chapter. And what we have in the state of Georgia, and I think every state, has some version of it. In Georgia, the Judicial Qualifications Commission is I think maybe the smallest state agency that exists, but it is an agency of the state, and its job is to, among other things, police judges in terms of any violations of the canons of judicial conduct. But they also do training and education and other things. but discipline is one of the big ones. And there's a process that they go through. They start by filing charges when it's appropriate. And then the judge at issue has the opportunity to have a trial, if you will. It's more administrative in nature. Chuck, feel free to correct me if I'm wrong, but it's not like a jury trial where you have jurors and that sort of things. But there are rules, and there's perhaps some rules of evidence and things like that. But the Supreme Court is the ultimate arbiter. I think the JQC trial will make a recommendation. And Chuck, correct me if I'm wrong, there was a recommendation made earlier to the state Supreme Court to remove her. And by that, I mean years ago. And the Supreme Court decided not to. Is that right?
That's correct. It was actually on 2 occasions. I believe we had made motions to suspend under Rule 15C. You can make a motion to suspend a judge if we believe that the judge would pose a threat to the administration of justice. And there are various things that can arise to. We've had several judges that have been suspended by the Supreme Court before we actually had hearings on the cases or trials on the cases. And so we had done that twice in the Supreme Court on both occasions, while saying, they had grave concerns about the allegations at the time. There had not been a formal hearing at that point, and they recognized that a trial would be coming at some point in the near future. So they declined to actually suspend at that point. You can also suspend a judge before an actual hearing too, if there is an indictment for a felony. But obviously an arrest for felony behavior would warrant a motion to suspend as well.
Okay. So we've got, that's certainly good. I learned stuff just by, talking with the guests that I have in here, people like you, because some of that's new information even for me. Count 2 gets into, it says between March and December of 2020, she failed to establish, maintain, and enforce high standards of conduct. This goes into some more posting at the Rose Bar on her Instagram, using her status as an advertisement, the birthday cash app. Right. Some of this is the same. Is Count 2 looks like it's more like an alternative way of the same thing in Count 1.
That's correct. Yeah, with a number of the way you have to actually file formal charges in a judicial qualification disciplinary thing. You may have, like with the same act in a criminal case may violate several different statutes. And because, we want to make sure that we're covered that, each one of these different types of or different rules within the Code of Judicial Conduct that it may violate, we want to make sure and have spelled that out, both for the judge to have notice and for the hearing panel in Supreme Court ultimately to be able to analyze it under the facts that are proven, and then also the law of the code that they're presented with.
So moving down to Count 7, looks like we get into some different stuff. Now, this is before she was even a candidate for judge, but as I learned today, when the JQC is investigating a judge for violations of the judicial ethics here in Georgia, they also have the authority, concurrent with the State Bar of Georgia, to investigate any, let's just say, unethical acts that the judge may have engaged in while they were a lawyer before they became a judge, right? So we're looking at December 2017 here.
Correct. And, this is something that happened to the couple of bigger cases we've had the last few years. When they reconstituted the JQC, basically our judicial disciplinary system was blown up in 2016 and reconstituted, created a completely different system with different rules, those types of things. And at that time, one of the rules that were instituted was that pre-bench conduct could be considered as a violation of the Code of Judicial Conduct. Obviously, we do a lot of times have violations that are both bar rule violations and Code of Judicial Conduct violations. So while they may be something that the judge may have to deal with the JQC regarding their job as a judge, they may also have to deal with an investigation by the state bar. Interestingly, in this case, there was a Judge Christian Coomer, who was a Court of Appeals judge that I had investigated and filed formal charges on. We had a trial on him as well, and he was actually the first judge after a trial to be removed by the Supreme Court. And that was before Judge Peterson's case trial had been started, about a year beforehand. And I say that within that case, there was some conduct. We had hearings, and the Supreme Court had never addressed pre-bench conduct or conduct by a judge that was committed before they actually were a judicial candidate or had been elected or served. Our rule had said that that was available to be able to use or to be able to charge that conduct. Several other states absolutely had the same rule. The Supreme Court did a constitutional analysis, though, and it determined in that case that in Georgia, per our Constitution and the way it's structured, a judge cannot be formally charged or disciplined for conduct that occurred before they were a judicial candidate or were elected or took the bench. So in this case with Judge Peterson, you'll see several charges within this formal charge document. These actually, Director Veal chose to dismiss, and rightfully so, before the trial, because the Supreme Court in the Coomer case had decided, look, you can't do that. This case had been charged before that, so we withdrew these cases. But funny enough, or not funny enough, this is an example of something that, even though much like in the Coomer case, there were examples, in this case, this is an example of something that the Judicial Qualifications Commission, the Supreme Court, says you all don't have jurisdiction. This could still be a problem for Judge Peterson, former Judge Peterson, if this was something the state bar would be dealing with or looking at, something they would be able to deal with independently.
Okay, so this stuff from 2006, this is all things that related to how she handled a lawsuit related to her homeowners association before she was a judge. And so if I understand you correctly, this was not part of her trial with the JQC, and it was not part of what the Supreme Court considered. Correct.
Yeah, because during the pendency of this case, the Supreme Court decided that conduct could not be formally charged. But it did become relevant later on, because there were charges that were filed that she was tried on for activity with the same homeowners association, where her behavior at the meeting was charged as being less than judicious. And she also basically tried to speak with parties who were represented with the HOA, knowing that these parties had attorneys. She was charged and found by the hearing panel to have violated the Code of Judicial Conduct by talking to represented parties, knowing that they had representation without their counsel present.
Yeah, and it also alleges things like she settled the lawsuit without consent of the co-plaintiff. She was also a plaintiff apparently herself. All right, yeah, because this talks about all sorts of things related to that homeowner association.
Yes, that's exactly what I was just talking about. What it led to in 2022 was this HOA meeting where the behavior was obviously we thought was prejudicial to the administration of justice and did not do anything to enhance the integrity of the court.
Okay, so looks like we're now. I'm at count 16. Again, a lot of the folks, for those of you who may be just joining us, we're talking with Chuck Boring, former director of the Georgia Judicial Qualifications Commission, now in private practice attorney. And these charges against the now former Judge Peterson, a lot of the counts, they kind of overlap. And you see, this is analogous to what you'll see in a criminal indictment, where the same alleged conduct might violate different laws. And so it's basically, the allegations are repeated, but they're repeated as a different violation of a different statute, in this case a different canon of judicial conduct. But we're down to 16 here, and it alleges that she made false and misleading statements to the JQC staff, to wit, quote, "I asked in the open training forum if my continuation as an AFPAG," and I'll let you explain what that is. That's some kind of an advocate, but we'll let you talk about that. And I was told by the probate counsel that it was not a violation. I may continue serving. I asked at the training amongst my peers. Melanie Bell was the instructor on the course on ethics, in which I directed my question to. However, other judges chipped in and agreed it was no issue. So, Chuck, first off, tell us what potential problems judges can get into when they serve in other roles in the justice system other than being a judge.
Right. And this is that would be a great example. This was something as an advocate in juvenile court on behalf of parties. And so this is interesting. This count, this allegation. This is one that and this is a trial strategy thing from what we talked about before I left, and then what Director Veal did when she actually tried the case. With paring down, because there were so many violations and so many different things that she had been alleged to have done and that we have charged. Getting ready for trial, we really wanted to focus it down. This is an example of one of those counts that Director Veal did not proceed on at trial, because with the severity of everything else that was alleged that had gone on, we figured that it would it wouldn't add anything necessarily and would probably prolong the trial. But it was one of the things, interestingly enough, it was with our office. And so we had gotten an email asking about this, and a comment had been made that when we asked further follow-up about serving in that position, she said, she had asked the people or her peers and Melanie Bell, the answer to the question. And she said they told her it was okay. And then, we ended up getting a statement from the parties and witness that from the witness that was in the charge there. And she said, absolutely. I said, you cannot do that. So that was why that charge was in there, because it was straight up, her telling us an untruth.
Okay.
But going back to your initial question of why it's important for judges to be wary of what they do outside of just their judicial job is, you can put yourself in Georgia, you're actually, if you're a full-time judge, you cannot practice law. You just can't involve yourself like that. Further, volunteering in other capacities within the judicial system could be a conflict as well. And that's why we have specific rules about behavior with the judicial system outside of your judicial duties. We do have a number of part-time judges in Georgia. Judge Peterson was not one of those, but there are some judges that are part-time, and they are allowed to practice law with some limitations. So, Georgia it's an interesting judicial system. When I took the job, I found out after I took the job that there were over 1,600 judges in Georgia. If I'd have known that, I probably would not have taken the job, because we ended up having to train, present, advise, give advice to, and investigate and prosecute, the entire state. When I started, it was 3 employees, including me, covering, over 1,600 judges from the Supreme Court all the way, to magistrate, superior state court judges, part-time municipal court judges in little cities. It was a lot, and there's a lot to cover, but that's just kind of the difference in Georgia. Some of those smaller municipalities and some of those other, smaller or lower jurisdiction courts will have part-time judges who do practice law, but that does get dicey, and there's specific rules that judges really need to make sure they follow if they're doing that balancing act. Got you.
All right. So the next, and this particular allegation, I remember it making the news, unless I'm mistaken, around the time that this all supposed to have happened. This deals with in April of 2017, the charge says Judge Peterson failed to act in a manner that promotes confidence, independence, integrity, impartiality of the judiciary. It says, when, after being advised by Captain Wilson, presumably of the sheriff's office in Douglas County, that she was not to allow civilians to enter the Douglas County courthouse because they could not be properly screened. And we're talking about after hours. She allowed 7 civilians to enter the courthouse without required security screenings in violations of courthouse security protocol. And it's my understanding, Chuck, this has to do with her performing weddings after hours and on the weekends. What's all that about?
Yeah, this was an occasion where the allegation was that she was scheduled to actually perform a wedding that day, and it was earlier that day. And evidently, wires got crossed about the time. The deputies said they'd been told one time earlier in the morning, because they had to have security there. For a judge to be allowed in the courthouse, and for civilians, not judges, but for the civilians to actually be in the courthouse, to be checked for security, make sure they didn't have weapons, make sure you're not bringing contraband into the courthouse, a number of reasons, especially on the weekend when there's not normal security there. So the deputies had shown up, and Judge Peterson, the wedding party, never showed. So they waited an hour or two, and finally decided they were like, okay, well, we're leaving. There ended up being phone calls between sheriff's office personnel and Judge Peterson about it. They said nobody's going to be there to let you in, and the allegation is she showed up anyway and let a bunch of civilians go into the courthouse as well to do this wedding unchecked and unsupervised. It just happened there was also another deputy who was off duty with a group leading them into the courthouse too, in an improper manner. And of course, that officer took responsibility for what he'd done and got sanctioned for it. And so from a judicial standpoint, that's why Judge Peterson was charged with that. And there were also other issues regarding statements that she had allegedly made to, as you see, Captain Wilson in this and the sheriff, that were a big note at trial because the hearing panel had found that some of those were probably less than truthful.
And in Georgia, for those who weren't aware, the sheriff in the state of Georgia is the person who is charged by law, I think by the Constitution, if I'm not mistaken, with security at the courthouse. So, even the judges have to kind of follow the sheriff's rules when it comes to court security. Listen, by the way, parenthetically, never let it be said that we're not fair here inside the law. We have apparently in our live chat tonight, we have former Judge Christina Peterson, and she's inviting people to hear her side of things and she says, learn the truth on her page. So there you go. If you want to hear what she says about all this, go check out her page. We are all about transparency and fairness. Is absolutely, I think that's great. The more knowledge, the more information people have, the better. All right. So there you go. Moving right along, we've got the next things, Chuck, I think, had to do with how she, let's see, this count 20 on it's number 230, paragraph 232. Okay, I'm sorry. This still deals, it's alternative ways of the same thing involving court security. We have, here we go. Count 22. Judge Peterson failed to respect and comply with the Code of Judicial Conduct when a probate clerk who is subject to her direction and control in violation of Georgia law and uniform probate rules failed and refused to provide copies of and viewing public records requested by investigator Alford and director Courtney Veal. And probate records, just like other court records, by and large, are public record. Anybody, for no reason or any reason at all, can walk in and look at them. Right. So what's up with this?
Yeah, and this was one that we had. I think this was in the midst of the investigation about the marriage at the courthouse. They went to try to find the name of the parties who were involved in the wedding, and so they now Director Veal and Investigator Alford had actually went to try to get the marriage certificate, and they were not allowed access in attempting to do that. And we're told that they would need to provide other kinds of justifications before they would be allowed to do it.
So let me see. So they identified themselves as being with the JQC, and they still were denied access.
Yeah, initially, I'm not even sure that they identified right off the bat. They may have. I can't remember exactly, but it could have been they just presented as normal civilians asking for records. But regardless, they did eventually know that they were with the Judicial Qualifications Commission. Yes.
Okay. So this one I thought was really interesting. Now we're getting into count 27, and this refers to an email that was sent by her to Judge Emerson, who was a Superior Court judge, and other governmental officials were copied on it. And the quote here is, "How are you even a judge?" Accused him of harassment, called his actions prejudicial and borderline racist, told him she prayed that his soul is saved, and asked that he please retire as the county has outgrown his spirit. Now, look, everybody's entitled to free expression, free speech, and exercise their First Amendment rights. But it seems to me that if you're on county email, using county computers, county email address, and you're making these statements to another judge and you're copying other government officials, it just seems like it's conduct unbecoming of a judge.
Right. And that's why this was included as a charge. I mean, judges have certain rights. I mean, you have the right to free speech, of course. However, there are limitations on that when you agree to and you desire to and you accept the job of judge. There are certain things that you have to sacrifice in order to keep the sanctity of the judicial process and the neutrality of the judge. You don't want people coming in think that with preconceived notions that you're going to rule one way or another, and they want to have confidence that you are competent and a steward of the livelihoods of people that come before you. And so anything when judges act in a certain way that really leads to the disrepute of the office of judge, then that's a violation of the Code of Judicial Conduct, because you're a judge 24/7, whether you like it or not. And how you behave off the bench and how you behave to other people is absolutely something that can bring you trouble with ethics charges.
Interesting. All right. So we've got the next thing that I want to get to, and I'm just kind of going down in order. Some of the ones that are, that struck me as really just weird. Activating the emergency panic button in her office, which, well, you tell us what it is. I mean, it's, all judges, well, most judges, at least where we practice, Chuck, have access to like a panic button, whether it be on the bench or back in their chambers or whatever, because emergencies do happen, right? We had, a murder in the Fulton County Courthouse, sadly, 20 or so years ago. But what was this all about?
Well, it was in the midst of all this back and forth between, the judge and the sheriff's office and court administration and officials, part and parcel of a pattern of behavior that was alleged. That in this case, you have an emergency panic button in case, somebody's got a gun, that there's a threat in the courthouse. Well, in this case, the deputy was a minute or two late coming to escort her from one place to the other, because she wanted an escort through the courthouse and to the court. She, because he was late, she hit the panic button. And obviously the law enforcement officials come hustling in and running in to see what's going on, and she's just waiting there. So that's kind of a, not necessarily, again, if this were one thing taken separately, one-time mistake in temperament or something like that, that's one story. However, when you've got a pattern of behavior showing just a complete disregard for the Code of Judicial Conduct, then that puts it all in context.
One of the big things that made the news was apparently there was a person who went in, someone we would call pro se. That's Latin, and it means you represent yourself, or in other words, you don't have a lawyer. So this person with initials PJ went in and filed to amend a marriage record, and she went in on her own. And apparently the judge, without a necessary or the appropriate hearing, made some legal determination that PJ had willfully provided false information on her marriage application and lied under oath over 5 years prior. Sent a notice which contained no mention of contempt allegations to PJ, ordering her to appear for an in-person hearing, purportedly referred to as a hearing on a petition to amend marriage record. And I guess she got there thinking it was a hearing on her petition, and she got locked up by the judge.
Right. And this was one of the more egregious, if not the most egregious example of the misconduct in the charging document, and as to what was proven at the trial and what Director Veal ultimately proved that she had committed. Basically, this poor lady who had come from, I believe, Thailand, when she came to the United States, she listed her uncle as her father on the birth certificate. And this was, or it was marriage certificate. So her father had never been in her life. And so her uncle basically was the closest thing.
Yeah.
So other than that, when years later, she decides, you know what, she actually learned the name of her biological father and, decided to change it. And when she went in, for lack of a better term, Judge Peterson, what the evidence showed, she okey-doked her, told her she was coming in for one thing, gave her no knowledge it was going to be a contempt hearing at all, did not give her the right to an attorney, didn't have a court reporter there. and basically locked her up and sentenced her to 20 days in jail. And then told her if she paid the court $500, the probate court of Douglas County, then she could purge it. And so that's what happened. And she ended up still spent 2 days in jail for this with no notice and basically an improper execution of contempt powers. And so, yeah,
we've talked about that on this show before too, in the context of the Young Thug YSL trial, where judges sometimes, I guess it's more commonplace than we thought. Well, first off, they forget what their authority is. They forget how to use it, or they just don't care. Or they try to mix civil contempt with criminal contempt, civil contempt being the kind of thing like, look, you're in jail because you didn't pay your child support. You get to purge the contempt by paying said child support, and you can get out whenever you want. Criminal contempt, it's a misdemeanor crime. You have the standard due process stuff that you have with all criminal cases. You got the notice and opportunity to be heard. You got a right to a lawyer, the right to a fair and public trial. It's a misdemeanor crime, I think, with a maximum of 20 days in jail. So you can't really give somebody the max criminal sentence and then say you can purge it as if it were a civil case.
Right. There were just so many things wrong. And, the irony, I don't know if it's irony, but that's one of the things when I was training new judges, and I know that the judges go through that when they go through new training, the severity of what contempt is and how to properly apply it. I mean, I've had slides in my PowerPoints on that to trainings for judges specifically. And so the tools were there. It was, the fact that it went down the way it did, ultimately, it seems like that was one of the main reasons the Supreme Court found the behavior inexcusable and removed her from the bench. And another part was, it appeared I know the hearing panel's ruling and recommendation honed in on numerous occasions where they believed Judge Peterson was less than truthful and talked about her behavior in the courtroom and on the stand. And that was one of the things about the evidence that was presented versus what she testified to were diametrically opposed. And that is something cited by the hearing panel and the Supreme Court in the decisions that led to her removal. All
right. I'm going to, at the risk of cluttering the screen too much, let me remove that. This is, the next count gets into something that we've also talked about here inside the law in another context. Judge Glanville, ex parte communications, and the rules are, judges, it says, shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impending matter, subject to some exceptions that, I don't think necessarily apply. Chuck, since this is your first time here, these folks have heard me talk at length about why I think ex parte hearings and discussions and communications are, it's just a dirty word for judges. But as the former director of the JQC, I'd like to hear your explanation as to why judges are not supposed to engage in ex parte communications.
Well, there's a number of reasons. One, it being an adversarial system, you could have one side get a leg up on the other if they're presenting their case without anybody to rebut it. There may be information the judge shouldn't hear that they're being presented with that the judge should not come before them. But it's the appearance of impropriety is one thing, feeling like or having the appearance that you're giving favoritism to one side or another. Also, you have an inability, you have a strict ban in Georgia on ex parte communications with very limited exceptions. And so, it's a bad look, and B, a lot bad can go on in ex parte communications. Now, when I was training judges, one of the main things I would do would say, understand ex parte is bad. If for some reason somebody talks to you and you're just sitting there and it just happens to be a party, you're at a restaurant and they start talking to you about their case, you can't just like run away from them. But you can tell them you can't speak. But the main thing is to also notify the parties immediately. If there has been an ex parte communication, you have to notify the opposing party as soon as you can. But, it just, there's so much that's why it's disallowed, is because there's so much bad that can come from ex parte communication. So I always tell judges, learn the exceptions, because there are exceptions. Like if you're going for a search warrant, obviously, or an arrest warrant, those are hearings before a magistrate judge that the law allows to be held ex parte. If you're seeking a temporary protective order because of domestic violence, a lot of times that can be done ex parte. If it's scheduling where the other party doesn't need to be present at the moment, that can be discussed. But aside from those few exceptions, it just should not happen, period.
Yeah, look, I've said this before, and I think this highlights it. I've said that, an ex parte communications alone are enough to cost a judge his or her office. And here we have, these charges right here. Count number 35 deals with this. It says searching for and initiating contact with Miss Mercado, a potential litigant in a pending probate case after the deadline for filing an objection had passed, and having had ex parte communications with Miss Mercado, and so it looks like emailing and talking. So this was, part and parcel of the Judge Peterson case. What was up with this?
Yeah, this was basically the judge and her staff taking it upon themselves and doing an investigator or another party's job for them, and actually located this other party to contact them to the detriment of the party that was moving to try to get what they needed in probate court. The person, Ms. Mercado, did not respond to certain filings, didn't meet timelines, and then the court, her and her staff on their own, decided to contact this party themselves and make suggestions about what to do and extend deadlines without even telling the other side.
And it looks like she then, without anybody applying for the services of a court-appointed lawyer. I didn't know that you're entitled to a court-appointed lawyer in civil cases like this, but anyway, she did just that. What's that?
No, you're not entitled to that. No,
well,
not as a matter of law.
She did. She appointed Attorney White at taxpayer expense and without any indigency determination to be paid out of, quote, the indigent fund to represent this person that she took it upon herself to locate without telling anybody else involved in the case, and a non-Georgia resident. So she appointed an attorney at taxpayer expense to get involved in this. What in the world, Chuck?
Yeah, it was, I can't explain it other than, it's just more egregious conduct. Appointing this attorney that doesn't even have a right and using county funds. But, it's interesting. There are a lot of, judges and constitutional officers in Georgia have a lot of leeway with their budget and what they can use it for. And so it's interesting. A lot of times I found in investigating judges, what may ordinarily think and not pass the smell test or be allowed, you would think sometimes are subject to their ability to make decisions about their own budget. So it's just really kind of a tangent, but it's something to note that, the separation of powers in Georgia are real. And, a lot of times you can't tell a constitutional officer how to spend their money unless it's in violation of the law or it's against some ethical standard.
The rest of the counts here, unless there's anything this is all more, failure to perform her judicial and administrative duties. And a lot of it's related to that same case. Right. And then I answer this though, if you can, maybe you don't know, but the Supreme Court took, a long time. Is that par for the course with how these things go? Or is that something that, was this case something that dragged out sort of longer than you might expect?
I think the case drug out a long time overall, not necessarily the Supreme Court's ultimate decision, but from the onset of the investigation to the end, because she kept violating the Code of Judicial Conduct, and we had to keep instituting new complaints and adding more charges. Once it got there, it did take a while, not only for the trial, because they had to stagger it into 2 different weeks over the course of a couple of months. And then the hearing panel had to write their decision. It takes a long time but for the staff, the hearing panel, who are the 3-judge panel who determines what happens in the case as far as making a recommendation, they sit as trier of fact in the trial. They're all volunteers. They all have day jobs. The judge he's a Superior Court judge who serves as a judge member. You have a Dax Lopez, who's a practicing attorney, a very busy attorney, former judge. He's also a member of the hearing panel. And then the citizen, Richard Hyde, he works as an investigator for a law firm and does a lot of other work too. And so you have to get all of these volunteers schedules together to be able to hold this type of thing. And under the JQC rules, there is a long time frame, a bit of a lengthy time frame for the discovery process. Unlike in the criminal sector, where it's a lot easier. It's like, all right, turn over discovery. Are you ready? Let's go. In the disciplinary process, there's accounting for depositions and, almost more civil akin discovery. So that takes a while. Then the Supreme Court, as you know, because this is going to be something precedential. And quite honestly, until I started in 19, over the past however many years of the judicial system in Georgia, there were only 20 Supreme Court decisions on judicial disciplinary matters, approximately, in that arena for the history of the judiciary in Georgia. And so when we started, I know a lot, myself and Director Dill, there's a lot of reading the tea leaves. Okay, how is the Supreme Court going to interpret this provision of the Code of Judicial Conduct or these particular rules? And so in that, the Supreme Court, it takes them a while to get their decisions out too, because they're setting the standard and the precedent for our judicial disciplinary system going forward for the next, 20, 40 years.
And let's face it, a lot of times, and this, I'm sure you and I both could, when we talk privately, we can probably recall some of the same names of judges who, but even before the JQC got sort of reconstituted a few years ago, when the JQC being, as small as it is, it's still the agency that judges fear the most, right? And so when the investigator from the JQC starts poking around the courthouse, the judge is going to find out about it pretty quickly. And a lot of times that will inspire judges to, maybe it's time to go ahead and retire and spend time with family, or maybe just not run for reelection after all. And so oftentimes, it was my experience, when the JQC came knocking, they already had their ducks in a row, and the judge figured, well, you know what, may as well just take this opportunity to take the high road and exit gracefully. So like you said, we didn't wind up with any opinions, at least not a lot, out of the Supreme Court, because oftentimes these things weren't contested.
Correct. Yeah. And it was that different system. It used to be a one panel system. Basically, the JQC commission was one group, and they were the ones who investigated and prosecuted and also served as judge too. And so, which it worked fine. And but at some point there were a lot of people that had a problem, and it created this bifurcated process where there are two different panels. So the people who investigate and prosecute are not the same as the ones who are the triers of fact. And it created a lot of different, much more extensive rules as far as, what was available to the judge as far as their defenses and that type of thing. So you ended up we've had more trials now because of that. Also, the Supreme Court now is a lot different than the Supreme Court, say, 20, 25 years ago. Their opinions are much more lengthy and involved in the judicial disciplinary process than a lot of the old judicial opinions. Very, very short. Don't get into a lot of the, the intricacies of the codes of judicial conduct. But, you're right. I will say, I tried during my time there to maybe not soften our image a little bit, but let them know, hey, we are here to help if you are doing the right thing. We're not just out there looking for scalps. But also, at the same point, there are going to be people in any profession who are going to be bad apples and, commit ethics violations and do wrong. And so, when that time comes, we wanted, obviously people to respect and know that they're going to be held accountable if they do that. And we had a number. I know under the old system that was a lot of the, the worry of judges. Okay, as the investigator showing up on my doorstep and coming for me. Nowadays it's not as much the case because there's so much process to it before somebody could even resign. But, we had a lot of cases, as did the previous commission, where we would show up and talk to a judge. I think it was at least 12 judges resign or retire based upon my investigation during, at least a 2-year span. And, you know, a lot of times you just sit there, hey, look, this is what we're investigating, just letting you know, here are the next steps. What do you want to do? And several times, you know, the judge would say, you know, they'd own up to it, or at least not want it to be publicized, the details of it, and would agree to leave office.
Well, I mean, and that makes sense. It's like, you know, look, if you have the opportunity to leave gracefully on, you know, and kind of save yourself the, you know, let's just not only the monetary expense, but the personal expense of maybe having your reputation tarnished and things like that. It makes a lot of sense. Look, the other day, Chuck, somebody asked me this question and I didn't know, and I just thought about it. And you're the perfect person to, I think, answer it. If there's a real urgent situation involving a judge that's engaging in like just obvious misconduct, does the JQC have any kind of like emergency power to act quickly, or does everything sort of take a little time? I didn't know the answer, and hopefully you do.
Yeah, I mean, we don't have to get a formal complaint. We can do what's called a JQC initiated complaint. If we have independently basically got a tip, and that's where some of the most serious allegations we got were people who obviously did not want to file a formal complaint against a powerful judge. And so we would get a tip and we would independently verify it and start our own investigation. And so that could happen, and it can be expedited in that, you know, that's where we have the Rule 15C motion to suspend, to expedite and remove somebody from the bench, or at least limit their judicial powers while the investigation's ongoing. And that's a high bar to reach. But yes, in an emergency situation, and we've had that numerous times, we had a judge who was getting investigated by the GBI and ultimately arrested. We knew we needed to invoke emergency powers which we did. We had another judge who had pulled a AK, was drunk and pulled an AK on a deputy out in another county. And, you know, it was at that point, we're like, okay, we need a motion to suspend in that matter. And there are other times where you have judges who may be arrested for crimes and or have been, you know, it's uncovered they've committed horrible ethical violations, and you need to then, you know, make a motion to suspend them until you actually can have a full trial.
So that motion, that's filed with the Supreme Court, and it's only the Supreme Court can do it.
Right. It's filed directly to the Supreme Court. And it's interesting, the judicial qualifications process, this, you know, the disciplinary process, it's kind of the opportunity for the Supreme Court to get as close to they can as playing trial judge sometimes. It is very interesting, the difference in how things move from in a regular civil or criminal proceeding in the court system as to how it goes with the judicial disciplinary process. But what the Supreme Court also can do, if we file the motion to suspend, is to send it down for an immediate hearing to the hearing panel, and they would then make a recommendation to the Supreme Court. So that's another option too. But the way we had done it over those first few years I was there was direct motion to the Supreme Court.
Gotcha. All right. Well, and so that makes a lot of sense. And so the JQC cannot unilaterally act, but they can move quickly. And as we've seen recently, in like the Brian Steele contempt, we've seen that the Supreme Court can act really quickly too, in terms of, you know, setting bonds and you know, setting things aside. Even when they're in adjournment, they can move pretty quickly. Speaking of the Supreme Court, I've got on the screen just one of the, I mean, this is another really, really long document, but this is a part, it's on page 56 of the Supreme Court's ruling in the Peterson matter. And it deals with this ex parte. And the reason I focus on this, Chuck, is because here inside the law, we've been looking at this young thug case going on down in Fulton County with Judge Glanville and the ex parte proceeding that occurred down there. And so we've been talking and learning as much as we can. And yesterday, Doug Weinstein was here with us inside the law. He's one of the attorneys involved in that case who had filed a mandamus action in the Supreme Court. And the Supreme Court basically said, well, you probably need to go back and start and do this in Fulton County. But by the way, if you do it in Fulton County, then you're gonna have to have another judge hear it anyway. And so by the time he refiled it in Fulton County, this Peterson ruling was out, and he was able to cite some language from this Peterson JQC case, and it deals with the ex parte book. And so what they have said, that they being the Supreme Court said, ex parte communications, permitting and sending communications to only one of the interested parties in the case diminishes, quote, public confidence in the independence, integrity, and impartiality of the judiciary and weakens the public's perception that the judge has afforded all the parties the same right to be heard. And he was able to cite that language in connection with his, mandamus, and then one thing leads to another, and then the mandamus becomes moot because Glanville does everything that the mandamus, he winds up doing it voluntarily, and so now the recusal is somewhere else. But they did put some very fresh language regarding how the Supreme Court feels about ex partes. And so I point this out because, this is just, right in the middle of an 82-page order, which, by the way, appears to be unanimous in removing her from the bench. But ex parte is the allegations against Peterson were wide ranging, and there was just a lot there. But I think it's illustrative of the fact that something like an ex parte in and of itself can be a violation sufficient to cost someone their job. Chuck, what have I missed? What is important about this case that the folks might want to know that I've neglected to bring up?
I think you've done a great job covering it. I mean, I think to some degree, one way or another, people throughout Metro Atlanta have followed the case because it's been so, it was honestly, unbelievable at times what was occurring. And so, one thing I would add is that, like I said before, it's sometimes not one thing or another because people make mistakes. Judges are human, and we want to give them grace too at times if there's things that are be corrected. But in this case, it was the totality of everything together. That, and I think another important thing, just for if you're a dork and really have any interest in judicial disciplinary issues, your candor toward the court and toward the commission makes a big difference, because it is very telling if you are willing to file paperwork, file affidavits, or testify during hearings or a trial, and be untruthful, disrespectful, and embarrassing to the judiciary. If that is something that that you do, you're a judge and you show that type of behavior, the Supreme Court's going to note it. The hearing panel noted it, because it goes to whether you are bringing the office of judge into disrepute and whether you can continue to preside.
Well, I've certainly learned a lot. I know I've been kind of keeping an eye on the chat over here. I know that the folks in the chat have learned a lot, and we really appreciate you taking the time. I've kept you over an hour. I told you 30 to 40 minutes. I apologize. I'll take you out to lunch one day in a week or so when we got the time. But I'd like to just say again, thank you very much for your time, and everyone watching live. I want to give you a big round of applause to Chuck. Let him hear it where he's sitting right now from wherever you are. Chuck, hope you enjoy the rest of your weekend, buddy, whatever's left of it.
All right. Thanks for killing it, Phil. Just kidding.
You bet. See you, Chuck. All right. So there you have it. That's Chuck Boring, the former director of the Georgia Judicial Qualifications Commission. I've been wanting to get Chuck in here for a while, and it seems like when this Peterson thing hit a couple of weeks ago and I was traveling, the timing just didn't work out. But I feel like we are really fortunate to get him in here. He's very knowledgeable about not only the Peterson case, but how the JQC works in general. And I know that with our discussions here inside the law on the YSL and other cases, there's been the question is like, how fast can something be done? And I think Chuck answered that question. And it doesn't, as you heard him say, it doesn't require a complaint from a citizen. They can take action on their own. And I happen to know for a fact that the folks on the JQC, they watch the news here in the Metro Atlanta area. And so who knows? I mean, what they do is secret, and, it's not a matter of public record until something formal is like filed. So who knows what what they may or may not be doing. Chuck, of course, is speaking only as a private attorney. He's no longer, of course, serving in that role. But, you know, I thought it would be very interesting to bring him here inside the law to give us his perspective on the realities of the way judicial discipline actually works. Yesterday, for those of you who were with us live, I don't know why, but the live stream just ended just absolutely just abruptly, and I don't know why, and I'm sorry about that. But one thing I was going to talk with you guys about last night is I appreciate your patience with me while I was traveling. I was in an area that had little to no viable internet access. I could get a tweet out here and there, and I could sometimes make a post, and I like to keep in communication with the folks, not only through social media, but for those of you who watch on YouTube, for example, we have the community tab, and I can make posts there. So make sure you subscribe and you set your notifications so that, if we want to communicate information or have a dialogue, we can do so, even if it's not in the context of making a video. You know what? I actually, that's not untrue. I actually was for a part of it. I was actually on a glacier. They're like, look, go ahead and drink the glacier water. It's perfectly fine. Just, and then of course I go to read up on it later, and then everything you read is like, do not drink the glacier water. It might have 3,000-year-old microbes in there that could kill you. But anyway, I didn't ingest any deadly microbes. My friend, Dear Woke Christian, thanks for the super chat, by the way. And he's one of our moderators, and I consider him a friend. He says he's inviting her to come to his channel tonight. So keep an eye there. Check out Dear Woke Christian's channel if you want to see what former Judge Peterson has to say. I mean, I thought it was certainly interesting that she's was in here in our live chat tonight, and maybe she still is. I don't know. But look, we're just here. We're talking. It is what it is. You guys can draw your own conclusions. The Supreme Court has reached a conclusion. It's a matter of public interest. It's the news, and we're here talking about it. So if you want to hear what she has to say, check out Dear Woke Christian. Hopefully he'll get her in there. I'm sure he'll have a great show. I was going to say, oh, by the way, speaking of where I was and what I was doing, I'm going to make my camera go away here just for a second. And then I want to show you. So one of the things I was doing is I've been a pilot for, a long time, many decades now. I got my seaplane rating. I learned to land seaplanes on lakes. And this is a lake that I landed on. And I drew these lines on that picture because I was showing you that I landed between those two lines to a full stop. So that's just one of the things that I wanted to just share with you. So anyway, so that being said, get my mug back on here, get that guy out of here. Thanks for being patient with me when I've been unable to do these videos. I do have some more traveling to do over the summer. Starting, as a matter of fact, tomorrow I'm going to be traveling some more, but I'm not going to be completely out of pocket like I was. And so my commitment, if there's anything that we need to do videos on, even if I don't have a great internet signal, I'll be able to maybe do a video and post it like a premiere. But of course, maybe we can get some lives in as well over coming days and weeks. But with that, I just wanted to again say thank you very much. We are surpassed well past 45,000 subscribers. I guess the next goal is 50,000. So tell your friends, tell your neighbors, tell your mail delivery person, anybody you can think of that may have an interest in this subject matter, maybe a casual interest in the law, a more than casual interest in the law, anywhere that somebody wants to, anybody that wants to learn how things really work in the real justice system. And just, look, if nothing else, folks, just remember, whatever you do, don't be this guy.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all, man. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang on.
All right, folks, don't be that guy. And I will see you back here next time inside the law.